evening or good afternoon, and welcome everyone to ARC's weekly Fireside Chat. Today, yes, on Prop 25, we'll be discussing modeling New Jersey's pretrial system in California. As always, before I introduce our amazing panel of guests that have deep experience in this area in New Jersey, I'd like to give a few instructions out to our guests. If you take a moment and look at the bottom of your computer screen, you'll see a number of icons. And what you can do if you like to communicate directly to our guests is either put it in the chat or put it in a Q&A. And as time permits, we will definitely answer your questions. Again, thank you everyone for attending. And again, we'd like to now introduce our amazing guests. Today, we'll be talking about how New Jersey worked together, united, to implement bail reform successfully. Let me say that again, successfully. And so on our panel, we have the Honorable Judge Glenn Grant, Appellate Division of the Superior Court. We have Jennifer Saletti, Deputy Public Defender and Director of Communications in the state of New Jersey, and our very own Michael Mendoza, Director of National Advocacy here at the Anti-Recidivism Coalition, ARC. Again, welcome everyone. Judge Glenn Grant, could you please introduce yourself and tell us a little bit about yourself?
Good afternoon to all of you. I am the Administrative Director of the New Jersey Court. I am one of 50 administrative directors across the 50 states. As the Administrative Director, I work with our Supreme Court, our Chief Justice, on deciding policy and operational procedures for our court system.
Thank you, Your Honor. We greatly appreciate you joining us. And thank you for this work that you've done and been a part of in New Jersey. It's amazing. I've read a lot about it and I'm like, wow, we have to get there here in California. Jennifer, Deputy Public Defender, please introduce yourself and share with us a little about what you've been up to.
Thank you. Thank you so much for having us here. My name is Jennifer Saletti. I am the Director of Communications for the New Jersey Office of the Public Defender. I spent many years as a trial attorney before coming to our headquarters, where I train all of our new lawyers and also still do take some cases, but primarily now my job is training. I get involved in policy and in handling a small number of cases that present kind of cutting edge issues in our law.
Thank you so much again for joining us. We greatly appreciate you and the work that you do. Michael, please introduce yourself and tell us a little bit about what you've been up to the last few days.
Thank you, boss man. My name is Michael Mendoza, and I'm the Director of National Advocacy. I've been a member of the Anti-Recidivism Coalition for about 6 years. Worked directly on SB 10 as a policy director in 2018 when we were able to successfully pass it in California. And I'm just excited to have our guests really teach us lessons from New Jersey on how we can move forward in California. So, thank you.
Thank you, Michael. Thank you for joining us. And so for our listeners out there, yes, on Prop 25 will make California the first state in the country to end money bail. The only other country in the world, in the entire world, that has unregulated money bail industry is the Philippines. The only other country is the Philippines. No, Prop 25 will repeal Senate Bill 10, passed in 2018 with former Governor Brown and current Governor Newsom and the California legislature in support of ending money bail. On August 14, 2014, New Jersey Governor Chris Christie signed a comprehensive bail reform legislation, Senate Bill 946 and Assembly Bill 1019. On November 4th, 2014, New Jersey voters passed a ballot question number 1 enacting this historic reform, which took effect January 2017. According to a 2019 report, the governor and the legislature of New Jersey, written by our esteemed guest, the Honorable Judge Glenn Grant, the public safety assessment tool has been used as a helpful resource when making pretrial decisions. Let me say that again, because this is the boogeyman in the room for California. The public safety assessment tool has been used as a helpful resource when making pretrial decisions. And so let's get right into it. We have the Honorable Judge Grant here, I believe, just for 30 minutes. And so we want to be wise in how we use his time and both honor his time and the wisdom that he can share with the state of California. So Judge Grant, Proponents of bail reform that include risk assessment say that this is an algorithm that will lock more Black and brown folks up. Can you tell us how the public safety assessment tool is used in New Jersey?
So the public safety assessment is a tool. And I think you have to take a step back and talk about what's the alternative to bail. Right now, bail is being utilized in many states across the country, and all judges are relying upon is person's prior criminal history and then their gut feel as to what that person should be detained or released or not. And what New Jersey was able to do with the support of great officers such as Public Defender Kokora, Ms. Sallutti's boss, and the attorney generals, we had multiple attorney generals doing this process, was to recognize that the old system, the bail system, is flawed in two ways. One, rich folks with access to money, even though they pose a significant risk to public safety, can get out. And poor folks who don't have access to money can be detained in our county jails for a substantial period of time. And so this collaboration, and this is what I think makes New Jersey unique, we had this broad-based collaboration that allowed stakeholders from all part of the criminal justice system to come together and allow us to create this process. So I don't want to say to you that this is a perfect system, because there is no perfect system. What I'm saying to you is this is a better system than what happened under the old bail system. And there's a couple of reasons for that. Number one, you get a consistency of what happens to a defendant, that the defendant's prior criminal history is going to be uniformly presented to the judge, prosecutor, public defender in that conversation. That doesn't happen everywhere. Number two, there are only 9 factors that are utilized in the public safety assessment that New Jersey relies upon. All of them are based upon the defendant's activity, except one. That is, if you're 20 years of under and have committed a violent offense. Number 3, with regards to this collaboration, it then moves the case through and still empowers judges, prosecutors, and the defense to decide how the case should be handled. So nobody gets pretrial detained based upon a public safety assessment unless the prosecutor files a motion for detention. The public defender's office then is allowed to demonstrate whether that person should or should not be detained, and the state, the prosecution, has to demonstrate that by clear and convincing evidence. So there's multiple decision points in our decision. It's not, as I was telling your colleague, this is not where the tool decides who gets into jail or who gets released. It is one of the tools used by all actors in the criminal justice system to advance these 2 competing interests. One is there's a presumption of innocence. And 2, there are some times when we have to be honest and admit there's sometimes people who are a danger to our community and they need to be pretrial detained. And so you're balancing these broad constitutional principles of the presumption of innocence, the right to be released generally, but then you're also saying, and what New Jersey did was the legislature passed a proposed constitutional balance saying we have the right to detain, and the constitutional amendment was passed by 67% of our citizens. So those 2 multiple factors, if you will, go into this whole process. But many times people will confuse and says, well, that tool is the only thing. No, Ms. Sellitti and her office are able to argue that, Judge, the same kinds of issues that we had before. This person doesn't have one issue before the court. That issue is now. The person has a connection to community. The person is not a risk. And candidly, our judges are granting motions for detention in less than 0.5% of the time. So that you still got, yeah, you're seeing that. And so now the more serious the charge, the greater that percentage go with. And you would expect that to be. If you're charged with murder, there's a presumption that you're going to be detained. And so the balance here is to say, is this tool better than not having nothing and allowing the individualized decision of judges to say, Judge Grant should be detained because I don't like the way he speaks. Judge James should be detained because I didn't think he had a connection to the community. I didn't think, the person didn't qualify him. No, this is based upon your activity. And that is, I think, one of the critically important conversations you have. The police decide whether the case even gets a summons or a warrant. A warrant says you go and you have to be reviewed by a judge. A summons says you can be released. And what we've seen as a result of this process is we substantially increase the the number of summonses that have been issued by law enforcement. Summons, that person is just given like a ticket and then, have to show up for court. Once you give them a warrant, you're going to go to our county jail and you have to go through that process. So we are empowering the decision makers at every step of the criminal justice process to use additional information to help make the best informed decision possible for that person's detention or not.
So I'd like to share with the audience, first and foremost, Judge Grant, thank you. That gives us a great deal of insight into, as you said, that's just one tool. The assessment is one tool, or the algorithm that everybody talks about. And I read about this algorithm. I call it the boogeyman because everybody who has not taken the time to really read it may not understand that it's just one piece of the puzzle, so to speak, or one part of the tool set that a judge has to make this determination. Mike, I want to go to you real quickly and ask, in terms of California Senate Bill 10, how does it compare in terms of that assessment tool, the district attorneys, the public defender, and the judges ultimately making that decision? Or is it just the assessment tool? They look at it and they say, okay, no, just the tool. Or is it more of, as Judge Grant described, you also had a DA, the public defender, or defense counsel that have an opportunity to weigh in?
Yeah, under SB 10 in California, yes, on Prop 25 would allow the same process to take place in California. Judges would also be able to consider this as just a tool, but consider other factors such as what the DA says and the public defender says. So we're right on line with New Jersey on those processes.
Interesting. So Judge Grant, Jennifer, as a public defender in New Jersey, what is your role during this process while the court considers the PSA or the public assessment and all other factors? What role do you play?
So I do want to start just by stepping back with a really important point that Judge Grant made, which is that we start in New Jersey with this proposition that release is the norm, right? And every stakeholder in this process, when we came together, from the Attorney General's office to the courts to the public defender, all came to this fundamental agreement that release should be the norm. And there are very few cases in New Jersey where there is a presumption of detention. It is only for murder and extended terms on first degrees, which may be a little different, I'm not sure, in California, but in New Jersey, so things like robbery, rape, attempted murder even would not qualify you for the presumption of detention. It is only if you have a record that qualifies you for an extended term to life in prison or a case that would expose you to life in prison. There are very few cases where there's that presumption. And that is important because the risk assessment, as Judge Grant has said, and as Mike, you have said, is a tool. And it is a tool that we look at, but also starting from this presumption that release is the norm. And it's a tool that the judge can use to evaluate certain aspects of the person who is before him. So as Judge Grant said, there are factors that go into the risk assessment, but where the attorneys come in is the same place they kind of always come in, and that's in storytelling. In telling the story of our clients' lives, of who they are, and all these things that a risk assessment can't tell us. So we are going to we present the story of, our clients' family ties, or work that they may be doing, the facts and circumstances of the offense. There's some cases that are stronger than others. So the attorney's job becomes an opportunity to say to the judge, this is the lens through which we want you to see the number that this risk assessment tool has put in front of you. And these are the reasons why you should be faithful to this idea that my client has a presumption of release, and only put those conditions on my client that would satisfy the court that he or she will come back to court and that he or she will appear to face these charges. So I think we've all said it, that it's the risk assessment is a tool. You start with the presumption of release and you use the tool as a guide to have that discussion, but there's so much more that goes into it than just the number that is on that piece of paper.
And if I would add, the issue about transparency, New Jersey consciously said, we're going to make that information which led to that calculation available to both the judge, the state, and the defense. And that it doesn't happen most places. In addition, we also said in terms of transparency, we're going to tell you what the factors are. So you know what is being considered. And Ms. Sellitti could have a case where she says, Judge, that conviction, even though it has the same name, is not my client. And we sometimes have to recalibrate the PSA, public safety assessment, based upon that information. So one, it's an openness to say, we are giving you this information and trying to do our best to make this prediction, because that's all it is a prediction as to whether the person will reoffend while out on release.
That's fascinating. Thank you both. That's fascinating, and I say that from the perspective of there's an additional, and correct me if I'm wrong on this, Michael, there's an additional level of oversight that California has proposed to provide under Prop 10, and then Senate Bill 10, and now Prop 25, and under Senate Bill 36 of 2019, which basically says that this information will also be public information that will be delivered to the state legislature to be evaluated to basically take a look at this assessment tool. Am I correct on that, Michael?
Yes, that is absolutely correct. One of the things that our champion, Senator Hertzberg, knew heading into SB 10 in 2018 was that California has so many counties, many more than most states. And so he passed a bill, SB 36, which would require the counties to be transparent if they use a risk assessment tool in place of bail under SB 36. They would have to be transparent and ensure the intent of using this tool does not cause racial or biased conclusions throughout the decision-making process.
And so our audience, so that you're clear and fully understand it, this is a level of oversight that we do not currently have in the state of California. Literally, the public will be able to access this information and see for themselves, and it will be delivered to our state legislature. Judge Grant and Jennifer, we're engaged in much discussion about the future, what the future could look like if cash bail ends in California. Has your work changed since the enacting of bail reform in your state? And what are some of the key takeaways on the other side of this discussion?
So I think you've got to, first of all, in New Jersey, we publish every month our statistics. We publish who was picked up on a warrant, who was released, what monitoring level they had, what motions were filed, what motions were withdrawn, and what motions were agreed upon by the judge. And that's a monthly system. And anybody can go onto our website and you can see our annual report as well as our monthly report. Matter of fact, we're getting ready to publish a report for September in a few moments today. So I think that again, that trying to that openness, and it really is, Sallutti's boss, Public Defender Kokora, has really been one of the principal reasons why we've been able to facilitate this program. I would be remiss, however, if I did not recognize that people that look like me have been systemically mistreated in the criminal justice system. And so when people say, well, are you using that history in your calculation of your public safety assessment? And the answer is yes, because that process will work whether you use a public safety assessment or whether it's an individual judge deciding on your prior history. Nobody is going to make a decision as to whether a person is released without looking at their prior history. And so one of the good things about New Jersey is we have been engaged in an ongoing effort on multiple levels. Most recently, our Supreme Court dismissed 800,000 parking tickets. Just yesterday, we dismissed another $142,000 worth of juvenile fines. Just yesterday, our court issued an order saying any juvenile who's failed to appear in the last 5 years should have that bench warrant revoked. We had a sentencing commission, which Ms. Sallutti's boss was on. We've enacted additional legislation. So when you talk about left coast and west coast, New Jersey is really at the cutting edge of recognizing there are some systemic barriers to how we treated people of color, and we're trying to address them. My boss, my Supreme Court just issued a big executive order identifying 9 things that they're trying to do this year. That's really how you address it. But to think that you're going to be able to not use a public safety assessment and not use that prior history is really not going to happen. There's no judge who's up for re-election. There's no judge who's going to say, I'm going to ignore this conviction. New Jersey is also trying to pass a marijuana law like you guys have in California. So we're trying to correct those things. With regards to the successes of the problem and also the challenges, we were able to substantially reduce our prison population without an increase in crime. So we reduced our prison population, our first year, about 3,000, and a majority of them, like I forgot the actual number, 1,600, I believe, were people of color. Right? That's a big number in terms of changing. And what I tell people is, while the system still has challenges, that individual person who didn't lose their job, who didn't lose their house, who didn't have the opportunity to have a conversation with their attorney on the street, that has huge implications. It's not a perfect system. I keep coming back to it. It's a better system than the bail system. We still have more work to do because what we still find is there's a disproportionality of individuals coming into the system of color. How do we address that? And that's where our state is now using that sentencing commission to look at prosecutor decision and other things to try to correct those. So we've made remarkable, if you know the history of bail, just being in jail for a few days, much less a few weeks, has catastrophic impact on you and your family. So this idea of you getting out, the law says that we have to have a release decision made within 48 hours. Stuart Rabner, who's our boss, says we want to try to do that within 24 hours. And we're doing that for about 85% of the defendants that come into our system. Within 24 hours, a release decision has been made. So the issue here is it's not a destination in terms of PSA, it's a journey. We're still working on how we can look at domestic violence because that's a significant community concern. We're still looking at, can we refine the document to get a better predictive value in terms of high-risk individuals? It's an ongoing effort, an ongoing exercise.
So I want to really drill down on something that you said, and this is a point that we've been sharing with people that are opposing in California. So it's people coming into the system that are disproportionately Black and brown. Yep. Coming into it, like if we just said that we had ended cash bail, yep, we would still have a disproportionate number of people of color coming into the system. Yep. Yep. And that's part of the problem. Yep. And so therefore, we have to also look at that piece of the problem too, and how DAs decide to charge, prosecute, et cetera, et cetera.
You had a very nice project. I don't know what happened where the San Francisco DA was looking to do a blind indictment. I don't know if that project is still going on, but that's some of the kinds of creative thinking that you're going to need to try to address this problem. It is a national problem. It's not unique to California or New Jersey. It's a national question. And so again, the question is, are you making things better for some people who come into the system? Are you improving the lives of people that are coming into the system? And we argue this is a much better, it's not even close. It is a much better process than the bail process we had before criminal justice reform took place.
Thank you so much for that, Your Honor. And I know because we only have you for a few more minutes, I wanted to ask both you and Jennifer this question. Skeptics of the initiatives like Prop 25 and Senate Bill 10 contend that this will lead to an expansion of our carceral state. Do you find that argument credible in practice in New Jersey?
No, quite simply, no. The documentation says we have substantially reduced our county prison population. We have done so, I think, in a way that has not impacted public safety. Public safety was not the intent here, but we have substantially reduced people who get released substantially increased the number of people who get released to our community. That's a positive result. As I said, we're still working on this thing. This is a work in progress, but to say, compared to the old system, where we did a study where 12% of the people in our county jails were in on bails of less than $2,500 or less. That's not fair. That's not fair. And so we said, how do we attack that issue? So I think that under any set of matrix that you use and having an honest conversation about how you are trying to create a better pretrial release system, not a perfect one, a better pretrial release system, you have to come to the conclusion that in comparison to bail, this system is remarkably better.
Thank you so much, Your Honor. Jennifer, would you like to, same question. Skeptics of the initiatives like Prop 25 and Senate Bill 10 contend that this will lead to expansion of our carceral state. Do you find that argument credible in practice in New Jersey?
Not in New Jersey. I mean, I agree wholeheartedly with Judge Grant. I mean, I think that there are some reasons for that. We often say that New Jersey is special because of a lot of reforms that we have been allowed to do, because we kind of all get around a table and think that we're going to knock heads, and then everybody will agree to some fundamental principle. And like I said earlier, we all agreed that release was the norm. We also agreed in the beginning, which was a really difficult concession that Judge Grant talked about, that there are some people for whom no conditions of release will satisfy the goals of bail. And that's a big pill to swallow as a public defender. You don't ever want to say that detention is appropriate for anyone. And it was a big risk. And at least personally, I can say in my mind, going to the voting booth and voting for an amendment that would remove my client's right to a monetary bail. That was really scary. But we all kind of rallied around this principle that most people were going to be released. So I think that is important. I think education is really important to making it successful. I can attest to the work that Judge Grant put in training anybody. And that's why we joked earlier about like this show being on the road and being rusty, because I know Judge Grant and my boss, Joe Kokora, and the Ellie Honig, who at the time was the Deputy Attorney General in charge of this project, would go out on the road together so that everybody in the room could see that prosecutors, defense attorneys, and judges were united in this purpose. And leading up to it, we did a ton of training with lawyers. I know Judge Grant did a ton of training with judges to say, forget about money, forget about money. It's if you think somebody is so dangerous that an amount of money is going to keep them in bail, then that is a person who should be detained, right? So even though technically our statute has money in it, we don't use it. I mean, the statistics on any time a money bail is used are so low that it's negligible. So I think the commitment, the training is important, and a very robust cite and release provision. That what Judge Grant was talking about with the people who were released on summons versus the people who were released on complaint warrants. We were able to reduce that dramatically by putting tools in the hands of police, by putting guidelines in place. The Deputy Attorney General, or the Attorney General, I'm sorry, issued guidelines that were very strict about when prosecutors should use a summons versus a complaint warrant. And there are very, very few cases in which a complaint warrant is mandatory. And those would be like first-degree crimes, murder, rape, attempted murder, right? Very, very serious offenses. That's the only time that a police officer has to detain someone, or at least have them go through the pretrial detention process. Everything else, there are presumptions written into the guidelines, but for the most part, we're seeing so many more people cited and released. So if you can do all of those things, right? If you can change the mindset, change the culture, educate people, train people on those goals, stay faithful to those goals, and keep as many people as possible from going into the detention process in the first place, it will be successful. And just like the tool is only successful if you use it the right way, the statute is only going to be successful if the people implementing it do it the right way and are encouraged to do it the right way.
Thank you so much for that.
I think Ms. Sellitti raises the broader question about community outreach. Even today, the judiciary is engaged in community discussions about the public safety assessment and CJR. As I tell people, bail has existed in the United States forever. And so we're into our third year of using a new process. We haven't put strong roots in the ground, if you will. So I get a monthly report on how many visits we have with our various communities, how many stakeholders, because my belief is this: there will be a significant event that will happen that somebody's out on release. It's just the nature. It happened under bail and will happen under what we call criminal justice reform. The question is, have you aligned partners to say, that happened under the old system, so why is it any different here? We're not looking to say we can predict what a person will do. We're trying to do the best of our ability to keep those two competing principles, release and public safety, together. And so I tell my staff that we've got to commit ourselves to years and years of investment in California, because you don't have a unified system like New Jersey has. Ms. Sallutti's boss is the state public defender, not ex-county public defender. He is the state public defender. He controls all 21 of our counties. The Attorney General is in charge of all law enforcement. The judiciary is in charge of all judicial assignments. So we have institutional strengths that other places don't. But it still comes down to the four things that you learned very early on: communication, collaboration. In our particular case, it is also technology. And then there's a willingness to be agile and adjust going forward. You really need those things if you're going to have, a tree that's going to grow strong and be part of the lasting change of our society. And I will be quite candid with you. I was sued multiple times when CJR came out, and so we've got to build that kind of institutional foundation.
Your Honor, thank you so much. We know you have other issues that you have to deal with. We had you till half past. I want to give you an opportunity for closing thoughts. And again, thank you immensely for sharing your knowledge and incredible wisdom that you brought to the show. So any closing thoughts for our audience?
So, I am a big believer in Dr. King, and you use the word arc on your t-shirt. And Dr. King talks about the arc of the universe bending towards justice. But we also have to recognize that there are counter forces that are also pushing with that question. So we have to be committed. We have to be passionate. We have to be dedicated to building that foundation, that partnership that I have. And in California, it's a huge state, 40 million people, multiple counties. So you've got a lot of work to do in order to build that strong coalition that will survive this change. Because trust me, the opponents of the past will be coming against this new protocol and procedures. I think this is much better than what happened in the old system. I know it's much better. I can document it's much better. And the question is our society brave enough? If our society is willing enough to embrace this new change? So I'm more than willing to talk to you guys about a lot of things, and we'll be following up.
Thank you so much. We greatly appreciate your time and the wisdom that you shared. We will definitely be in close contact as we continue this journey on making our system better. Thank you.
Please stay well.
Hi, Judge Garrett.
Stay well, Mr.
Thank you, Your Honor.
Jennifer, so that was incredible. I want to point out something. I didn't get a chance to say this. So New Jersey's latest report that I read this morning, New Jersey's pretrial, or I think this is from 2019, New Jersey's pretrial population has declined by 43.9%. 43.9%. And they use the boogeyman, the algorithm, the assessment tool, as one of the pieces, just as we would use in California. It's one piece of the puzzle. And so just want to say that one more time. Pre-trial detention in New Jersey has decreased by 43.9%. And the other thing we touched on for a moment was when I went to jail, when I was arrested, I had no bail. My commitment offense was for murder. I had no bail. I couldn't bail out. Even if I was rich, I wouldn't have been able to bail out. And so when we look at who would not be able to bail out, regardless if there was bail reform back then, I still would not have been able to be released, just as I was not able to be released when I was arrested with bail. Jennifer, are there further system changes you would be in favor of as it relates to pretrial reform?
So I echo what Judge Grant said about this being a work in progress, right? We're always trying to look at what we're doing. We know that it is better than the old system that we have, but no system is perfect. I think, I hate to just echo what Judge Grant said, but I think we're all really on the same page here in New Jersey, that attempting to remove racial disparities from our system and any kind of implicit bias in risk assessment tools is important. It's also in many ways impossible. And as Judge Grant said, if the choice is between the risk assessment tool we chose, which was the public safety assessment designed by the Arnold Foundation. If the choice is between that and having some judge who all that they have is whatever baggage they have that they're bringing to the equation and deciding the bail or stamping a number on a client and saying this is the amount of money that will ensure their release, I much prefer the tool. That being said, people of color are more likely to have interactions with the police, are more likely to have things that may change their score on the risk assessment. I think we chose the best risk assessment tool possible, but no risk assessment is ever going to completely eliminate racial disparity in the system. So we have to strive to do whatever we can to keep that out. Part of it, that is our job as advocates. Part of it is, as Judge Grant said, is keeping our eye on the numbers, looking at the numbers of people who are being arrested and or being detained, and looking at the racial disparities in our prison systems and our jails, and then making other kinds of reforms. For example, sentencing reform, which is something that we're doing in New Jersey and we're working on here, and a lot of the police transparency efforts that we have going on in New Jersey. So I say something like, I would like to see us eliminate racial bias from the risk assessment, full well knowing that that can never happen, but still echoing the idea that we should continue to strive to make that happen in whatever way we do it, whether that's by continually looking at the risk assessment directly, being very aware of its impact on Black and brown people in our communities, and doing other things, whatever else that we can do to remove racial bias from our justice system to the extent that we can.
Thank you so much. Michael, I want to ask you a question in terms of, so let's say Proposition 25 passes, and so Senate Bill 10 stands. Can we go back to the legislature and say we want a specific assessment tool, or we want to add in a part to this particular legislation that says we'll use pretrial services or create a pretrial service branch where that's who would do the assessment? Is that possible once Prop 25 passes?
Yes.
For us to go back to the legislature?
Simple answer is yes. The best thing about a yes on Prop 25 would allow California to continue to amend SB 10 to make it better. But you know what, Sam? There's something that I also want to ask Jennifer. Jennifer, you said something earlier that I thought was very important from the perspective of a public defender, as a factor that the judge has to consider when making this decision. Can you talk a little bit about how that perspective in partnership with the community is a critical factor when the judge is making a decision, aside from just looking at the tool?
Yeah, so there are a whole bunch of things. The tool is really based on, as Judge Grant said, based on prior history, the types of offenses in a person's prior history, the number of times they have appeared or not appeared, and then really the only biographical information that it includes is age, because unfortunately, age is a risk factor. Everything we know about the human brain and all that case law about adolescent brain development, we know that people who are younger are more likely to reoffend or engage in impulsive behaviors. So that's why that one is there. But it doesn't contain what I would consider to be more subjective information, which is your employment, your ties to the community. Actually, our risk assessment, I should jump back to the earlier point about race and context with the system, it does not include juvenile history. So that's something that's really important, because particularly when you're looking at the effects on Black and brown communities or Black and brown defendants coming into the system, juvenile contexts become really important. Now, that's something that the prosecutor is going to bring up as part of his or her arguments before the judge, but it doesn't go into the calculation of the score. So it's to the extent you can keep juvenile history out of it, you do get at eliminating some of the bias that might creep into this. But yeah, so things like, employment, ties to the community, anything positive that they're doing, employment history, drug programs that they might be in, or alcohol program, anything good, anything positive, anything that would bear against whatever that risk assessment score may or may not be. So all of those things, and it includes evidence about the case. So if we look at a case and we say this is really weak, there's a strong motion to suppress or whatever, the facts of the case become important as well. And we have a chance to sort of, I don't want to say litigate them, because we don't litigate the facts of the case at a detention hearing, but we have a chance to get more discovery about the case, because the prosecutor, if they're seeking to detain someone, has to give us more discovery than we ever had before. So now 24, 48 hours after the offense, we have more information. We can use that to rebut the likelihood of success at trial, which is another factor. So there are some suggested things that attorneys can argue, but an attorney can argue literally anything that they want outside the risk assessment. in order to convince a judge that a person shouldn't be detained or that a person's level should be lowered or whatever that might be.
So
You
thank
did. Oh, okay, go ahead.
No, go ahead.
I did want to make a point about pretrial services because you alluded to pretrial services before. And I think that that's something that's important too. We do have a pretrial services system in New Jersey that is different than probation. It is not probation officers. And that is important because I think with pretrial services comes a clearly defined role that it is their job to keep people on the path that we expect of them when we set their pretrial conditions. And then that becomes something that we can use to argue that somebody should stay out, right? They've been doing a really good job on pretrial services. They're passing urine screens, they're going to treatment, they're doing whatever it is they need to do. And then it makes it easier for us to go back into court and maybe negotiate a favorable plea or get the prosecutor to drop charges or whatever it is that we want the prosecutor to do for that particular client because she has demonstrated such success on pretrial release.
So thank you for that. I want to ask you specifically, how has bail reform in your state affected the pretrial assumption of innocence?
So it's an interesting question. I don't know if it directly impacts the pretrial presumption of innocence from like a public perspective. I think what it allows us to do is a couple of things. I think first of all, it allows us to take this pressure that we used to have all the time of people pleading guilty just to get out of jail. Right? I can tell you stories all day. We don't have enough time for me to tell you stories about clients who had really, really great trial issues or really, really great motions to suppress, but then they've been in jail for 6 months, 7 months, because back then we didn't have speedy trial either, which is a whole other part of this. And they would offer them probation. And they'd say, I want to get out of jail. I don't care if you can beat my case 6 months from now. I don't want to wait for a trial. I want to get out of jail. So we've eliminated that. We've taken the pressure off of most people to feel like they need to plead guilty to get out or to resolve their case. The other thing that it does is enables us to be better partners with our clients as we prepare for their case at trial, right? Like I can now go to the crime scene with my client. I can have my client in my office instead of being, in a conference room at the jail with an officer walking back and forth, right? My clients are always a partner with me in investigating and trying their cases, but now my clients are out and free to do that with me in a way that it can be more meaningful than when you have a client who just can't go with you to a place or can't sit with you for as long as they want. And then I think the third thing about that is, as I alluded to before, it gives them an opportunity to demonstrate that they are capable of reform before there's an offer, right? So they can be on pretrial release for 6 months, get clean, graduate from a drug program, start working, right? They can do all these things, and it makes it a lot easier than to resolve their case in a way that is more favorable should they choose to resolve their case short of a trial. So I don't know if it changes the presumption, but it changes the opportunity, I guess, for our clients.
Let me actually, this is from our chat box. We actually have a question that says, what has the record been like for people actually using the pretrial support services? Has that been helpful? Has that helped to decrease failures to appear and things of that nature?
Yeah, I mean, before, as I mentioned before, New Jersey really didn't have a speedy trial system, and we had no pretrial services at all. So what pretrial services does is they call people and they remind them to show up for court. They make sure that they're complying with the conditions. If they get off track, they may come in and help a person, get back on the conditions. And the nice thing about the New Jersey statute is if somebody is messing up, right? If somebody's messing up their pretrial release, you don't just go back and get launched to prison. Jail. You don't get launched to jail. You go back and the judge still has to ask the question, are there conditions of release that would satisfy the goals of the statute? So if you have somebody who's released with very few conditions, but they're still using drugs, they're still, having some problems, the judge may say, okay, now you have to do urine screens once a week. I'm going to up your conditions. So you don't go from being on the street to being locked up. You go from, it's always, the question before the court is always, can I satisfy the goals of this statute without incarcerating this individual? And if they can, then they'll, change the conditions of release. So in that way, pretrial services can be helpful. Of course, it always depends on who your officer is and how well they work with you and a lot of other factors. But in theory, yeah.
Thank you so much for that, Jennifer. I want to go right to you on that point, Michael. So Senate Bill 10, the conditions of release. Is that the same question that we're asking?
Yes, I think the same question that we're asking would provide the similar tools and supports that New Jersey provides in their SB 10.
So for our audience, just to make it crystal clear to you, what conditions or what can we do to release this person to the public and ensure both public safety and that this person will report to court? And if this is just impossible, then that's one thing. Or if it's a capital offense such as murder, which you don't get bail for right now anyway, then that would eliminate it. But the question is, what can we do to release this person? That's the first question that's addressed. And the assessment tool, the boogeyman, as I like to call it, is just one of those pieces of, or one of the tools used to determine what that is, or how do we determine to release this person. And so, again, want to go back to, because I think this is an amazing number, pre-trial population in New Jersey has decreased by 43.9%. That's almost, if you think about it, 43.9%, that's huge. That's almost half. And so that's a lot of people that aren't sitting in the county jail waiting to go to trial. And my question would be, one more question to you, Michael. My question would be simply, in terms of with many people, like you've read the assessment tool, in terms of if we want to change this assessment tool once Prop 25 passes, how difficult would that be? Based on your experience doing legislative work, policy work in California, how difficult would that be?
Sam, not at all. And I say that based on not only my personal experience working on policy in California for the last 6 years, but ARC as an organization, CJ reform as a movement in California has experienced, a lot of tremendous successes through bills that have been amended throughout the years to be improved. And so in California, it's as if we are meeting folks where they're at to push as much as we can. But in this case, the most important thing that a yes on Prop 25 does is completely end money bail. And that was the intent of SB 10, the most critical goal that we've been in search of for the last 3 to 4 years in California, following on the heels of New Jersey and other states. And so we are fully confident that in the following years, as we see the transparent data come out, we continue to keep our eyes on New Jersey and collaborate with other states as well. And then just being hopeful. We have one of the most monumental elections coming up, not just in the presidency, but it's in the state of California, in LA County and in other counties. And we're hopeful to come out from that end with key players in California that will help us implement SB 10 appropriately. And when we need to adjust it accordingly, we will all do so together, just the way New Jersey did. So I really enjoyed hearing from New Jersey, specifically how they work together to get this done. So I believe we can do the same thing in California as well.
Thank you so much, Michael. So Jennifer, we're almost at time. However, I would love for you to give your thoughts to our California people as we approach this election, and we're looking for a yes on Proposition 25 because we believe, as it has been done in New Jersey, that this will decrease the number of people that are currently in our county jail, and that this will actually benefit many, many people that are currently sitting in the county jail right now that just can't bail out. And want to also point out, California actually has the highest average bail in the entire nation. So our bill, I'm quite sure, is higher than the bill that people in New Jersey will have to pay. And so that's why we probably have more of the issues with people not being able to bail out. So last thoughts and ideas that you'd like to share with the people that are listening.
Yeah, well, once again, I wanted to thank you for having both Judge Grant and me here. It's really nice to be able to talk about that. And I always get very proud of my state when I have an opportunity to talk pretrial justice reform with anyone. So thank you, and thanks for the work that you're doing. I think really it comes down to, like I have said, it comes down to, you create these tools and they really then fall into the hands of the people who are using them. So whether that tool is a statute or that tool is a risk assessment, it comes down to the mindset that people bring to them. So I think it is really important to think about release being the norm and to narrow those categories of offenses for which a person has a presumption of detention. It's collaboration. We've all talked about it. We've been talking about it, is truly important, working with prosecutors and judges. And, I mentioned earlier the training that Judge Grant had provided. We had done some training. We did training together. We did training independently. In all of that training, also then after the statute was enacted, we would meet in meetings with the judiciary representatives from the AG's office and the public defender's office to say, how are we doing? And there was a period of time where we were meeting every single month and looking at numbers from across the state, meeting with the technology people. So anybody who was a stakeholder in the system would be in the room, and we would keep stats on where we were going, what was working, what was not working, how can we nip problems in the bud before they become truly systemic. So that's, I think, another important point. And then again, using that risk assessment in a way that is responsible and not making it the be all end all, but making it a part of a larger argument. And then of course you want to maintain public safety and, crime in New Jersey. You mentioned the drop in pretrial incarceration. We've also had an 18% drop in crime.
Wow.
So this idea that public safety is threatened. And I will tell you, the bail bondsman came at us with both barrels, every barrel possible. There were websites that said it was going to be like The Purge, the movie The Purge. They had a Purge website. And then crime dropped because you're giving people the tools to maintain the ties with their family, to be successful, to keep their jobs. There were studies that said within 4 days of being locked up, people are more likely to lose their job. And I apologize, I forget which organization did it. But all of the, as Judge Grant was saying, within hours of being arrested and held in jail, you are losing from your life. So I think the ability for people to continue on with their lives, even though they have criminal charges pending, and to better their lives through the assistance of pretrial services folks who are not probation officers and not police officers, but they're truly in a more rehabilitative capacity. All of that coming together is what made New Jersey successful. And I learned a long time ago working on some stuff with people in California that I don't pretend to understand how California ballot initiatives and politics all works, because you guys have some weird relationships between your statutes and your ballot reform measures. But I can say that's why New Jersey works. And if you have the tools in place to make that happen in California, then it will work. So I hope that you do and can gather that kind of collaboration there.
Thank you so much. Thank you for being a guest. We greatly appreciate the wisdom and knowledge that you've shared with us. Michael, last thoughts for our audience.
I think my last thoughts, especially after hearing the Honorable Judge Glenn Grant and you as well, Jennifer, and all of the work that New Jersey has done to really get really good reforms going. I think for us in California, we're at a really important stage with all the work that we've done. We're at the 2020 ballot. We are going to be defending our wins that we've fought for in the last 10 years. And yes on Prop 25 would help that. It would help that because it would eliminate a multi-billion-dollar corporation that has really been detrimental and predatory towards people of color, people like myself, people like those of us who are ARC members formerly incarcerated. We know all too well how unfair that money bail system is. And so when we look at the 2020 ballot, when we look at what New Jersey has done, New Jersey has exemplified the values that we are trying to instill in our organization at the Anti-Recidivism Coalition. Values that bring us together, that allow us to work as a coalition, and we have built a strong coalition in California. This is not the time for us to undo that, but instead to grow and build stronger together, as Jennifer and the Honorable Judge Grant and so many others in New Jersey on such a tough issue work together to accomplish. And so I'm really excited about what we can accomplish following in their footsteps with the strong values of a strong coalition that works together. So that's what I'm excited about, Sam.
Thank you so much, Michael. Greatly appreciate you joining us as always. And I'd like to end with a thought that I've had. First, I'm impressed with New Jersey. They approached this boldly, with courage, and they changed it, and it's paying off. 43.9% less people inside. I shared a few nights ago, as a Black man, as a person who's been in our system, as a person who deeply understands my history and the history of my forefathers and foremothers who came to this country in chains. Could you imagine if people had went to people that were enslaved and said, hey, listen, we're thinking about releasing you, but this is what you're gonna have to face. They're gonna be black codes, they're gonna lock you up, they're gonna lynch you, you're gonna have to fight for over 150 years, there's gonna be Jim Crow, there's gonna be dogs turned loose on you, there are gonna be people that are gonna try to hunt you down, you have nowhere to sleep, nowhere to eat, no profession, but we're thinking about release you. We're thinking about letting you go. We're thinking about ending slavery. Or you can stay here with the master where you have a home and a place to eat and where you work. If you don't take this, you have to fight for 150 years to be considered, or 150 plus years to be considered equal. And it's gonna be hard. They're gonna do all these bad things to you. Could you imagine what people would say? I think my forefathers and foremothers would say, free us and let us boldly go into what the unknown is. I like to end by quoting Harriet Tubman, who said she would have been able to free more slaves if they had only known they were slaves. I want to thank everybody for joining us this week. Next week, meet with us again. We will post what our next topic will be. I greatly appreciate you again, Jennifer, and the amazing work that you're doing in New Jersey. We will be in contact when we pass Prop 25, because I think the key to California getting it 100% right is the training that Judge Grant mentioned. And I think we would actually be smart to ask leaders from New Jersey to come down and train our judges and our judiciary on how to make this change. Again, thank you, everyone. Take care, God bless, and stay safe.
Thank you.